3 million pages of evidence, thousands of unsealed flight logs, millions of data points, names, themes, and timelines connected. You are listening to the Epstein Files, the world's first AI-native investigation into the case that traditional journalism simply could not handle.
Welcome back to the Epstein Files. Last time, we walked through the immunity list and tested what the records could actually prove without speculation. Today, we are examining victims kept in dark and mapping what the documents show about actors, timeline, decisions, and institutional response. As always, every document and source we reference is available at epsteinfiles.fm. So the first record is Judge Kenneth Mara's February 2019 ruling in the Southern District of Florida, which found that federal prosecutors violated the Crime Victims' Rights Act by failing to notify victims before finalizing the plea deal.
And that ruling, it really is the anchor for this entire part of the story. It's the forensic audit performed by the judiciary years after the fact.
Right. It's not a journalist's opinion or an investigator's theory. It's a federal judge's finding of fact.
Exactly. And the central finding is a violation of the CVRA, the Crime Victims' Rights Act. This act provides specific statutory rights. These aren't just, suggestions for good conduct. They are the law.
And what specific right was violated here, according to the ruling?
It was the right to confer. The right to confer with the attorney for the government in the case. Judge Mara, in that Jane Doe 1 and Jane Doe 2 versus the United States case, he pinpointed that failure. The prosecutors did not confer with the victims before they finalized the non-prosecution agreement, the NPA.
Before being the key word there.
It's everything. Because the moment that document is signed, it becomes a binding contract. The legal reality on the ground changes permanently. Any objection after that point as well, it's significantly harder.
So let's map out how that actually happened. The ruling describes a sort of a bifurcated timeline, two parallel tracks running at the same time.
That's a perfect way to put it. On one track, you have the U.S. Attorney's Office for the Southern District of Florida negotiating intensely with Epstein's defense team. And we should remember, that team was stacked with former high-level prosecutors. They knew the system.
They knew exactly which levers to pull.
Mm-hmm. And they were hammering out the details of this NPA.
Yeah.
Everything from the immunity clauses, the exact wording, to the sex offender registration requirements. This is all happening in late 2007, early 2008.
Okay, so that's track one, the secret negotiation. What was happening on track two?
Track two is the communication, or the lack of it, with the victims and their attorneys. The documents referenced in Mara's ruling and what you see in the House Oversight files show a consistent pattern.
Which was?
When a lawyer for one of the victims would call the U.S. Attorney's Office and ask for an update, where are we with the federal investigation, they were told it was ongoing.
Just a standard holding pattern response.
Exactly. Nothing to see here. The investigation is proceeding as normal. Some of the correspondence even suggests that they were actively led to believe a federal indictment was not just possible, but, maybe even imminent.
Well, at the same time, that indictment was being rendered impossible by the NPA they were drafting.
That is precisely what Judge Mara found. He used the word concealed. The government concealed the existence of the NPA from the victims until after it was signed, sealed, and delivered.
And by doing that, they effectively neutralized the victims' rights under the CVRA.
They mooted them. It's a legal term. You can't object to a deal if you don't know it exists.
Yeah.
You can't ask a judge to review the terms of an agreement that is being kept secret from you. By the time they were informed, it was a done deal.
So fast forward to 2019, this ruling comes out and the Department of Justice has to respond. We have their response, the USA response from June of that year. They didn't just say, our mistake.
Oh, not at all. They came out with a very technical legal argument, a defense that rested on the definition of a single word.
When does a right attach?
Precisely. The government's position was that under the CVRA, an individual does not legally have the standing of a crime victim until formal criminal charges are filed in a federal court.
So no indictment, no victim.
In their view, yes. The logic was breathtakingly circular. It went like this. We have chosen not to file a federal indictment against Jeffrey Epstein. Therefore, for the purposes of this federal statute, there are no federal crime victims. Therefore, we had no legal obligation under the CVRA to confer with them about the deal we were making.
But the deal itself was the very reason no charges were filed.
It's a perfect catch-22. The secrecy of the deal is justified by the absence of charges and the absence of charges is guaranteed by the secret deal.
How did Judge Mara react to that line of reasoning?
He rejected it completely. He found that the government cannot weaponize a non-prosecution agreement to circumvent its obligations under federal law. You can't make a deal to resolve a person's federal criminal liability and then claim the victims of that crime have no right to be heard because you chose a piece of paper instead of an indictment.
So the victims were vindicating. The court said their rights were violated. But what was the practical remedy? Did the ruling tear up the 2008 NPA?
No. And that is a huge point of confusion. The remedy Mora granted in 2019 was what's called a declaratory judgment.
Meaning the court just declared something.
It declared that the government had acted unlawfully. It put an official stamp on the victim's grievance. It was a massive moral and legal victory. But it did not, at that moment, invalidate the NPA itself.
So the immunity for the co-conspirators held?
At that point, yes. The 2008 contract, however flawed its creation, remained a legally binding document. The government got its wrist slapped, but the core of the deal remained intact, which is why Epstein's 2019 arrest in New York was so significant. It was a different district, charging different crimes.
To really grasp how the DOJ ended up in a position to make a deal like this, we have to rewind. It didn't start as a federal case.
No, it started local,
Yeah.
Palm Beach Police Department. And the documents show there was institutional friction from very early on.
The May 1, 2006 letter.
Yes. From Michael Ryder, the Palm Beach Chief of Police, to Barry Krischer, the state attorney. This document, it's really something.
It's formal, but you can feel the frustration, the anger just boiling under the surface of the professional language.
It's a declaration of war in bureaucratic terms.
Right.
Ryder writes, and I'm quoting here, "I continue to find your office's treatment of these cases highly unusual."
For a police chief to put that in writing to his supervising prosecutor, that's a massive step.
It's an explosion. He's documenting a failure to communicate. He's saying his lead detective, the person actually investigating the crimes, can't get the assigned prosecutors to return her calls. He's building a paper trail of obstruction, or at least severe dysfunction.
And he's not just complaining, he's forcing their hand.
He is. With that letter, he formally submits the probable cause affidavits. He's saying, "My department has done its job. We believe there is enough evidence to arrest Jeffrey Epstein, to arrest Sarah Kellen, to arrest Haley Robson. The case is now on your desk. What are you going to do?"
He even goes so far as to suggest the state attorney should disqualify himself from the case.
He does. He asks Krischer to examine the unusual course his office has taken. This wasn't some retrospective complaint years later. This was the head of the local police force, in real time, in 2006, saying something is deeply wrong with how this case is being handled at the state level.
And that friction, that reluctance from the state is what eventually pushes this into the federal system.
Correct. And that's where the NPA is born. We've talked about the secrecy, but the actual text of the deal is just as important. Specifically, that immunity clause.
The 2008 plea deal document.
It's the key. A normal plea agreement is defendant-specific. John Smith pleads guilty. John Smith's case is resolved. This MPA, however, was expansive.
It granted immunity from federal prosecution, not just to Jeffrey Epstein.
No, it granted immunity to any potential co-conspirators.
Any. Not a list of names, not the following individuals, just any.
Any. It is a blanket absolution. It covers everyone, named associates, unnamed employees, recruiters, schedulers, anyone who could potentially be charged as part of the conspiracy.
Yeah.
It's a global release of liability.
And based on the record, the Jane Doe filings, the House oversight documents, the victims had no idea this clause existed.
They were completely in the dark.
So a young woman who was victimized, she might have reluctantly accepted that Epstein himself was getting a lenient deal, but she would have held on to the hope that, maybe the woman who recruited her could still face justice.
That's a completely logical assumption. You assume the accomplices can still be pursued.
But the government had already traded that right away in a secret negotiation.
They had. They made a deal with Epstein's lawyers that they would not bring criminal charges against anyone in his network for these crimes in that district. By keeping that clause secret, they prevented the victims from ever having a chance to stand up and say, "Wait a minute, this isn't justice."
It wasn't just closing the case against one man, it was closing the book on the entire operation.
It was. And when you look at the internal DOJ documents referenced in the Office of Professional Responsibility report, you start to see why. There are hints of an institutional mindset.
What kind of mindset?
That this case was a headache. That it was fundamentally a state-level prostitution case that had been, dumped in their lap by a local police department that was frustrated with the local prosecutor.
So the goal became resolution. Just get it off the books as cleanly and quietly as possible.
It seems that way. And the biggest obstacle to a clean, quiet resolution would have been the victims themselves.
Because if you notify them, as required by law,
If you notify them, they object. If they find out about the global immunity for co-conspirators, they don't just object, they go to the press. The deal becomes politically radioactive. The U.S. Attorney's Office is facing a firestorm.
so the secrecy wasn't an oversight. It was a tactical necessity to ensure the deal went through.
The record strongly suggests it was a calculated institutional decision. The mechanism required to land the plane was secrecy.
So let's talk about the specific people who are left out. The documents in what we're calling Record Cluster 4, they aren't just abstract. They list names, dates, places.
Right. This isn't just about the Jane Does from the Palm Beach investigation.
Yeah.
When you look at compilations like the list of 28 girls or the depositions from the Jeffrey versus Maxwell civil case, you see the true scope of the allegations stretches over decades.
And across the country.
And across the country.
Ah.
For example, the records include the claims of Stacey Williams. She alleged she was groped by Donald Trump at Trump Tower back in 1993 after Epstein had introduced them.
So more than a decade before the Palm Beach investigation even started.
A completely different time and place. Then you have the allegations from Mariah Bellato and Victoria Hughes concerning the Miss Teen USA pageant in 1997. Again, a totally separate context.
Did federal prosecutors in Florida in 2007 and 2008 reach out to any of these other potential victims?
The record indicates they did not. Their investigation was narrowly focused on the list of victims they inherited from the Palm Beach police.
But the deal they signed wasn't narrow at all. The immunity it granted was global.
And that's the disconnect. You have a narrow investigation resulting in a broad, all-encompassing grant of immunity. So you could have a situation where a victim from, say, New York in the 1990s had her potential path to justice against a co-conspirator closed off by a deal she never knew existed, signed by prosecutors who'd never even heard her name.
It's a legal black hole. They created a situation where allegations could neither be proven nor disproven in a criminal court.
Exactly. And that failure to establish a factual record in 2008 is the direct cause of the chaos we see later on in the civil litigation. Everything becomes a battle over credibility fought with depositions and email dumps a decade after the fact.
Which brings us to Record Cluster 5, and specifically the Sarah Ransom emails. These became huge news when they were unsealed.
They did. The source document to look at here is the Request for Confidentiality Modification filed in the Jeffrey v. Maxwell case. It was a motion filed by lawyers representing Alan Dershowitz, who was an intervener in the case. They wanted to unseal a series of emails Ransom had sent to a journalist.
And the content of those emails was explosive.
It was. Ransom claimed in the emails that she, or a friend of hers, had videotapes. Tapes of high-profile men, including Bill Clinton, Donald Trump, and Richard Branson, with young girls.
Let's be extremely precise here. The documents show the existence of the emails making the claim. Do the documents show the existence of the tapes themselves?
No. That is a critical distinction. The public record contains the emails. It does not contain the videos. When you cross-reference this with the evidence logs from the 2006 Palm Beach raid or the 2019 federal raid in New York, those specific tapes are not listed as items seized by law enforcement.
So we have a claim of video evidence, but not the evidence itself in the public file.
Correct. We don't have documentation for the actual videos.
So why on earth would the defense team want to unseal emails containing such damaging allegations against powerful people? It seems counterintuitive.
Because their strategy wasn't about the powerful people. It was about destroying Sarah Ransom's credibility as a witness.
Ah. So they weren't trying to prove the claims were false. They were trying to prove the accuser was unreliable.
Exactly. The legal filing argues the emails are inflammatory, salacious, and defamatory. The defense's goal was to paint Ransom as a fabulist. They pointed to other things in the same email threads claims she made about having unhackable devices or trying to get help from Russian entities.
The subtext being, this is not the behavior of a credible, stable witness.
That was the argument. If she's making up these elaborate, almost cinematic stories about Russian spies and unbreakable gadgets, then how can a jury trust her testimony about the sexual abuse? It was a direct, brutal assault on her as a witness.
And this whole messy fight over credibility fought in civil court years later, it all stems from that original failure to prosecute criminally.
It's a direct consequence. Had there been a criminal trial in 2008, evidence would have been presented. Testimony would have been cross-examined. A jury would have made a finding of fact. But the secret MPA prevented that. It left a vacuum, and that vacuum got filled with years of litigation, speculation, and unverified claims.
And that vacuum also became a breeding ground for theories about intelligence agencies, blackmail, and state-sponsored operations.
It did, and we have to be very disciplined when we look at the documents here in what we're calling Record Cluster 6.
The record shows the topic came up. The deposition of John Alessi in the Giuffre v. Maxwell case, for example. The transcript shows lawyers asking questions about Black Cube, an Israeli intelligence firm.
Yes, the questions are in the record. A lawyer asked about it. But a question from a lawyer during discovery is not evidence that the thing is true. It's just evidence that the lawyer was exploring that angle.
So when we audit the core legal documents, the actual indictment from 2019, Judge Marr's ruling on the NPA, is there any judicial finding that Epstein was working for an intelligence agency?
None. There is no finding of fact from a court and no admission from the government in these records that validates the claim he was an intelligence asset for any country.
What about the file we have titled CIA and Project Monarch? That sounds pretty definitive.
I examined that document closely. It's in the dataset, yes, but it appears to be a general backgrounder on MKUltra and related conspiracy theories. Crucially, it has no docket number. There's no cross-reference linking it specifically to the evidence filed in the United States versus Jeffrey Epstein case. It's an ancillary document, not a piece of core evidence.
So to be clear, based on the approved public records for this case, we don't have documentation linking Epstein's trafficking operation to a state-sponsored intelligence program.
We do not. We have claims, we have lawyers' questions, but we do not have authenticated evidence or judicial finding in the files we have. What we have documented, beyond any doubt, is the domestic institutional failure.
So let's synthesize that timeline of failure one last time. Put the key documented events in order.
Okay. The timeline of how the victims were kept in the dark is clear in the records. 1. It starts in 2006. Palm Beach Police Chief Ryder sounds the alarm. He documents the unusual behavior by the state attorney and files probable cause affidavits, but the case stalls at the state level. Step 2, 2007 to 2008. The case moves to the federal system. Federal prosecutors in Florida begin negotiating the non-prosecution agreement directly with Epstein's team, and they insert that crucial case-killing any potential co-conspirators immunity clause.
Step 3, the deception itself.
Right. While these secret negotiations are happening, the prosecutors are telling the victims and their lawyers that the federal investigation is still active and ongoing. They are actively concealing the existence of the deal that will end that investigation.
And finally, step 4.
The reckoning. More than a decade later, in 2019, federal judge Kenneth Mara rules that this conduct, this deliberate concealment, was a direct violation of the Crime Victims' Rights Act.
The documents prove a calculated decision was made.
They absolutely do. The record proves that the Department of Justice, at that time and in that office, made a conscious choice to prioritize finalizing a plea deal with a well-connected defendant over fulfilling their legal, statutory obligation to the victims of his crimes. They insulated the deal from the very people it would affect the most.
In summary, then, the documents prove a clear, judicially confirmed violation of the CVRA. They prove a deliberate strategy of excluding victims from the plea process. We can see the conflict between local law enforcement pushing for prosecution and state and federal prosecutors pulling back.
But the record does not contain authenticated video of the alleged assaults on high-profile figures, nor does it contain a confirmed documented link to a specific intelligence agency, despite the prevalence of those claims in witness emails or lawyers' questions.
The system failed in a way that the documents can trace, step by step.
Next time. Life is Registered Offender.
You have just heard an analysis of the official record. Every claim, name, and date mentioned in this episode is backed by primary source documents. You can view the original files for yourself at epsteinfiles.fm. If you value this data-first approach to journalism, please leave a 5-star review wherever you're listening right now. It helps keep this investigation visible. We'll see you in the next file.